olden times in Europe, if you were accused of a crime or misdemeanor, you had to go through what they called trial by ordeal. This was an idea that first surfaced some 3,000 years ago in the time of Hammurabi. One of these ordeals called for you to plunge your hand into boiling water. 3 days later, if the hand healed, you were pronounced innocent. Another trial by ordeal was even more extreme. It demanded that you be tightly bound and thrown into the water. If you floated, you were guilty. If you sank, you were innocent. Was this fair and impartial justice? They thought so. The idea of justice has come a long way since those medieval times. For we Americans, no trial by ordeal, no divine right of kings or emperors, no dictator's orders or whims. At the very foundation of our democratic society is a guarantee to each and every one of us of the right to a fair trial by a jury of our peers. Each day, thousands of individuals, judges, attorneys, court officials, police officers, jurors, are called upon to uphold and protect our most basic human rights. Today, it's your turn. I'm Ed Bradley of 60 Minutes.
When I got my jury summons, my heart sank.
I said, why me? I do not want to serve.
I have a lot to do at the office. I have a lot of projects right now, and I'm thinking about them.
I'm wondering what kind of case that's going to be.
Could it ever go over a week?
Do I have the right to judge anyone?
Will I be asked to serve on a case where there will be photos or evidence that's unappealing, that's upsetting?
I guess one of the concerns is, the exposure of your personal information.
Jury duty is a pain in the you-know-what.
So you've been called for jury duty. You've had to drop whatever you were doing, leave your jobs and families, sacrifice days out of your lives to come and sit here with a room full of strangers. Is it worth it? And what is this service called jury duty anyway? The first known juries developed in ancient Greece, 400 years before the birth of Christ. Aristotle wrote that accused persons should be allowed to argue their case before a tribunal of peers to reach justice. The Romans threw out that idea, substituting a system of laws and judges, no juries. After Rome fell, for centuries, justice depended on who was wielding the sword, without judges or juries. Those were the days of trial by ordeal, including the water test we saw earlier. In medieval France, King Charlemagne occasionally brought together a group of well-born citizens to inform him of any local crimes or land actions. They were called the jurare. In England, this idea evolved into a system whereby the authorities, usually servants of the crown, called in neighbors of an accused person to serve as both witnesses and triers of fact. Usually 12 in number, they were expected to say what the crown wanted. In the 17th century, William Penn, who later founded Pennsylvania, was preaching on a London street when he was arrested and tried for disturbing the peace. When the jury refused to find him guilty, they were thrown into prison. Judges reversed the case, and from that day on, no authority could punish a jury for its decision. This English legal tradition came to America with the first settlers. But here, to the annoyance of the English kings, it developed a character all its own. In 1735, a man named Zinger was brought to trial in the colony of New York for publishing newspaper articles denouncing the corruption of the local English governor. The governor packed the jury with cronies and demanded they find Zinger guilty. They refused and struck one of the early blows for jury independence. Over the next few decades, the spirit of democracy expanded throughout the colonies, culminating in the late 1700s with the Declaration of Independence, the Bill of Rights, the Constitution. These pronouncements, and particularly the Fifth, Sixth, and Seventh Amendments to the Constitution, established once and for all in this new independent nation the rights of an accused to a fair trial by a jury of one's peers. In 1860, the first African Americans began to serve on juries. It took another 80 years before women were allowed to serve. But today, every U.S. citizen is eligible, rich or poor, of any religious or racial background, which means that every citizen can actually participate in our justice system. Today, after all this evolution, we know more than ever that the right to a fair trial cannot be ensured by police or other authorities. It can only be ensured by the direct, day-to-day participation of we the people. And that's why you are here today.
What a rich source of material our legal system has been for the entertainment media.
The mastermind, him. It was all his bright idea.
What's going on here? Who is that man?
Unfortunately, a lot of what we see on screen and read in books is exaggeration. Or dramatic license.
Let her alone! Let that man approach the bench.
You think I was gonna sit there and let you put her in a gas chamber?
Johnny, don't!
It's all right, baby. I knew you'd never talk, but I don't trust that other dame.
Johnny!
I won't let you take the rap for me. Yeah, I did it.
Isn't it wonderful how on television the guilty party always confesses just in time for the show to end, just before the closing credits? Well, don't look for quick and simple solutions like these in your jury trial. In real life, things just don't happen that way. Hi, I'm Diane Sawyer, and I'm going to take you through the way it really is, what you can expect when you sit on a jury. Of course, one of the reasons courtrooms and trials are so popular with the media is that in many ways, they are like dramatic theater. First of all, we have conflict, a dispute between two parties that comes to a final showdown in the courtroom. And we don't know how it will come out until the trial ends. In a criminal trial, we have on one side the people of the state of New York represented by a prosecuting attorney. On the other side, a defendant charged with violating a state law or laws. The trial is to decide if in fact a law was violated. In a civil trial, we have a plaintiff, a party who claims to have been wronged, and on the other side, a defendant who allegedly committed the wrongdoing. The trial is to decide if in fact there was wrongdoing and how the dispute should be settled. Other differences between a civil and criminal trial include the number of jurors who sit on a case and the standard of proof to be applied to the evidence presented. The judge in your particular trial will explain these differences to you. Another similarity between courtroom trials and dramatic theater is that each features a strong cast of characters. We have the judge, who is responsible for the conduct of the trial in accordance with the law. There behind the stenographic machine is the court reporter, who must transcribe and produce a certified word-by-word record of the trial. Over there you'll find the court officers, the people charged with maintaining order in the courtroom and, according to the judge's instructions, attending to the jury. And then we have the clerk, who swears in the jury and all witnesses and is responsible for all documents and physical evidence in the trial. At those two tables facing the judge, we have the disputing parties, represented by counsel. In a criminal trial, one table is occupied by the prosecuting attorney, representing the people of the state of New York. In a civil trial, instead of a prosecuting attorney, we have the attorney for the plaintiff, the party who claims to have been wronged. At the other table sits the attorney for the defendant, the party accused of the wrongdoing. In a civil trial, neither the plaintiff nor the defendant need actually appear in court. And now all the characters of the drama are in place except for one vital part, the jury. That's going to be your role. As you know, jurors are selected randomly. Once you've been chosen, you and your fellow jurors will be asked to sit through a process known as voir dire, a French phrase that means literally to see them say. During this process, attorneys representing each of the parties to the dispute will ask you questions to see you say.
Can you base your verdict solely on the evidence and the law?
Yes, I can.
Remember, the attorneys for each party want to wind up with jurors they feel will be most receptive to their arguments. So if you are excused during this process, it is in no way a reflection on your intelligence or integrity.
Juror number 9, juror number 11.
Sometimes when you're sitting on a jury, it may seem as if all you're doing is a lot of waiting around. But to the contrary, the catalyst for the resolution of the lawsuit is the fact that you are there, ready to hear the evidence and render a verdict. You are not just sitting around, but rather playing an indispensable role in our justice system. But now, let's take a look at the flow of a typical trial. Whether you're serving on a civil or criminal trial, there's a general procedure that is followed.
Are the remaining jurors satisfactory to the people?
Once you are selected as a juror, you will be sworn in by the clerk.
Will the jurors please rise and raise your right hands? Jurors, do you solemnly swear to try the case of the people of the state of New York against James Smith, the defendant at the bar, in a just and impartial manner, to the best of your judgment, and to render a verdict according to the law and the evidence, so help you God?
I do.
I do.
Ladies and gentlemen of the jury, I submit to you by the evidence that will be presented to you.
You may hear opening statements by the opposing attorneys, each presenting their sides of the dispute. This is not evidence. This is the way they see it.
Finally, I am confident that after you have heard all the evidence, you will return a verdict of not guilty.
Then, under the watchful eye of the presiding judge, the accusing side will present evidence to support their argument. Witnesses, exhibits, documents.
No further questions, Your Honor.
Mr. Edwards, what is your occupation?
The attorney for the defense has the opportunity to cross-examine these witnesses.
Have you ever been convicted of a crime?
Objection.
There may be interruptions from time to time when the attorneys huddle with the judge. These discussions concern points of law and are not meant for the ears of the jury.
The defendant has no burden to prove anything.
Next, the defense may present its evidence. This presentation may, in turn, be challenged by the opposing side.
Ladies and gentlemen of the jury, we have come to the end of our journey together in this case. You've heard all of the evidence, and now it is time to do it.
After both sides have presented their cases, they will make closing arguments. And now it comes down to you, the jury.
Members of the jury, we have now reached the point in the trial where you are to assume your active function as jurors.
The judge will instruct you as to how the law applies to this case, and you will retire to deliberate. During the deliberations, all you need to be a good juror is an open mind, fairness, the ability to reconsider your opinions, and common sense. Were the witnesses telling the truth? Was the evidence credible? What are the actual facts of the case as you see them? Remember, your opinion is equal to anyone else's in the jury room. Once you've reached your verdict, the court will hear it.
We, the jury, find the defendant, James Smith.
And that's the end of your service. Of course, every trial is different, but whatever the case you sit on, you're most likely going to find it fascinating. According to studies, most people who serve on juries come away with a more favorable view of our legal system than they ever had before. But this is the important part. Remember that when we serve jury duty, as many thousands of us do all the time, all over the country, we are not only guaranteeing the rights of others to a fair trial, but guaranteeing these same rights for ourselves and our families.
All across New York State, from the biggest cities and counties to the smallest, you'll find a great variety of courthouses. But no matter how different they look on the outside, inside these structures, the promise is always the same: a guarantee of justice for all. Since our nation's earliest days, the right to trial by jury has been at the heart of that guarantee. We could not preserve and protect that right without the participation of jurors like you. I'm Jonathan Lippman, Chief Judge of the State of New York. More than a decade ago, the court system launched a comprehensive program of jury reforms to assure a jury service more user-friendly for the hundreds of thousands of citizens who serve each year. I'm happy to report that those improvements are making a difference. Today, our jury pools represent the entire community in all its diversity. Today, every eligible person in our state has the opportunity to serve, and every eligible person is called. There are no more automatic exemptions. Today, jurors are summoned less often and serve for shorter time periods. We've added many new conveniences, such as the ability to complete qualification questionnaires online or by telephone. We know the arrival of a jury summons may create scheduling conflicts, so jurors are allowed one automatic postponement up to 6 months. For those of you who are interested, we provide internet access in many of our juror waiting areas, so you see, we're paying attention to your needs. Detailed information about jury service for jurors and for employers can be found on our website. The fact is, we know how valuable you are to the system, but the system is extremely valuable to you too. Like voting, jury service gives you the opportunity to participate in a very direct and personal way in our great democracy. As you will see, the decisions you make as a juror can profoundly affect the lives of our fellow citizens. That's an awesome responsibility. And I suggest you think about this. What if someday you found yourself in court as a party to a dispute? Wouldn't you want an impartial jury of your fellow citizens judging the facts? I know you would, as would I. So welcome to jury duty. By being here, you show that you care about our democratic society and your place in it. I know that you are going to learn from the experience and hope that you will carry that knowledge back to your family and friends. I gratefully thank you for your service.
You don't often get to participate in the government, and this is one way to do it.
It's a privilege for me to be able to help, to serve to other people.
Being a juror is a chance to let my voice be heard.
Certainly, it's the best system we've seen yet.
I don't think the system works 100% perfectly. It can't as long as the human element is involved. But I think if you have 12 people, you have a much better chance, I think, of having justice done than if you appear before only one person.
I believe we have the best system there is. It inconveniences my everyday life, but on the other hand, if we want law and order in our country, if we want fairness, we all have to come out and support it.